All right. Thank you so much for joining us today for the Employment Department's listening session. We will get started in just a few minutes. Thanks to everyone who has joined us. We still see some folks coming in, so we're just going to 2 more minutes just to make sure that we kind of hit critical mass before we get started. So thanks again. Just a couple more minutes. All righty. Good afternoon. Let's go ahead and get started. If you would like access to simultaneous interpretation for this listening session, first click the interpretation box from the menu at the bottom of your Zoom window, or click the More button to see it. Then choose Spanish. This meeting is also being interpreted in American Sign Language. Those interpreters will be highlighted on your screen. For Spanish, the presenter's voice will be lowered while the interpreter speaks over it. You can choose to mute the presenter if you prefer. We'll also put these instructions in the chat. So welcome to the Oregon Employment Department's listening session for Monday, August 4th. My name is Lindsay Leahy, and I'm the Unemployment Insurance Division Director here at the Oregon Employment Department. We'll begin by going over how the listening session will run and introducing our panelists. I will then present a summary of the 3 rule changes that the Employment Department has drafted, and after that, we will take your questions and comments. I would also like to remind everyone that comments can also be submitted by emailing OED_rules@employ.oregon.gov. Make sure to include the full rule number in your comment and submit those comments by September 4th. We will be taking written questions and comments through the question and answer or Q&A function on Zoom, as well as taking verbal questions and comments. Once I have presented the draft rule summaries, our panelists will begin providing written answers in the Q&A box, but we might also provide live responses to some questions as needed. Click on the Q&A button to access that feature and ask your question or share your comment. After I finish presenting the draft rule change summaries, we will open the session to live questions and comments. To participate, click the raised hand button. Communications Officer Seth Gordon will call on people in the order they raise their hands and will unmute your microphone when it's your turn to speak. We ask that you wait until we start that section of the meeting before raising your hand. Please make sure to state your name and organization if you are representing one, and let us know if you have a question or a comment. Today's listening session is scheduled until 5:30 p.m. However, we may end early if there are no additional questions or comments. Please keep in mind that this is a public webinar that will be posted online, so it's not safe to share your personal or business information. If you need help with your claim, please use our Contact Us form at unemployment.oregon.gov/contact or call 1-877-345-3484. You can also reference the information we will be presenting today at our listening session webpage, and that link will be posted in the chat. We will take the feedback we receive into account when we go through our official rulemaking process this fall. We are using these more informal listening sessions to enhance the official process to make sure that people have a chance to provide their perspective, so we thank you for participating. Once again, if you would like to view the simultaneous interpretation of today's session, click the interpretation button in the bottom Zoom bar. If the information button isn't displayed, click on the More button. Once you've selected interpretation, then choose Spanish. The meeting is also being interpreted in American Sign Language. Those interpreters will be spotlighted throughout the meeting. Now I'll have our panelists who are here to help answer your questions introduce themselves, starting with Sarah Cromwell.
Good afternoon. I'm Sarah Cromwell, the Unemployment Insurance Division Deputy Director for Benefits.
Good afternoon. My name is Lisa Schreiber. I'm the Unemployment Insurance Division Deputy Director for Operations and Policy.
Hello, I'm Carol Fisher. I am the UI Compliance Manager.
Also with us here today is our moderator, Seth, and our Zoom meeting coordinators, Stephanie and Perla. And with that, let's jump into the draft rule changes. So I'd like to start with our draft change to Oregon Administrative Rule, or OAR, 471-010-0105, which covers customer information and disclosure. The new language is in Section 4, subsection B. We are updating this rule to clarify that if an attorney has not been retained for purposes related to ORS Chapter 657, meaning unemployment insurance, a release of information request is required and must meet all requirements of informed consent. This includes a minor change to correct the reference to another section of the rule. Moving on to OAR 471-030-0050, Section 3 on benefit payments. This is a small change to remove reference to the specific brand of stored value cards that the Employment Department uses as one of our methods for benefit payments. The most significant changes we have drafted are to OAR 471-030-0036. Specifically, this rule establishes what it means to be able to work, available for work, and actively seeking work, which are some of the eligibility requirements for people who file a weekly claim for benefits. We are updating this rule for two primary reasons. The first is to modernize our weekly eligibility requirements to make sure they reflect how the Oregon economy and workforce have evolved in recent years. And the second is so that we can implement Senate Bill 916, which passed during the 2025 Oregon legislative session and allows 10 weeks of unemployment insurance benefits to striking workers. On the second point, I want to remind everyone that the Employment Department's role is to implement the law. We are seeking feedback today about that implementation, but not about the law itself. Okay, so let's get into the four changes to modernize our weekly eligibility rules in response to changes to the Oregon economy and workforce. Currently, there are several different requirements for claimants in various situations. The draft rule, Section 3, reduces that to two primary requirements that apply to all claimants. Claimants will be considered available for work unless they miss an opportunity for suitable work or they are unavailable for more than half the week. We believe these requirements will be easier for claimants to understand and therefore make it easier to provide accurate information when filing their weekly claims and answering questionnaires. It will also make it easier and faster for the Employment Department to determine whether claimants are eligible for weekly benefits and reduce the number of false issues that need to be investigated, but don't ultimately end up being something that would deny benefits for that week. The second change of this kind is to update how many work-seeking activities claimants must complete each week. Currently, they must perform a total of 5 work-seeking activities, including 2 direct employer contacts. Direct employer contacts are activities like asking about available work, applying for a job in the way that an employer wants, or attending a job interview. Work-seeking activities are things like searching websites for job openings, updating a resume, or attending a job fair or training. We propose keeping the 2 direct employer contacts, but eliminating the 3 additional activities because we have found that claimants who are making these direct employer contacts are already completing these additional work-seeking tasks every week and will continue to do so even if they are not required. We also believe that removing them will streamline the weekly claimed process for claimants without hindering their job search. Additionally, it will reduce the number of false issues that the employment department must investigate that will ultimately end up not being something that causes the legitimate eligibility issue that would result in a denial of benefits. The third change involves claimants who are out of work but expect to return to work with the same employer as outlined in Section 5, subsection B. We want to change the term for these claims from temporarily unemployed or temporarily laid off to employer attached because we think this will be less confusing for claimants, especially when filing their initial claim. We also received feedback from employers over the years requesting that we remove the requirement for their employer attached workers to actively seek work with other employers. So we are proposing that to be considered actively seeking work, employer attached claimants will only be required to stay in contact with their employer and not miss an opportunity to work for their employer if they are called back to work. Currently, there is a 4-week limit where employer-attached claimants are not required to look for work with other employers. This change, would remove that limit. In addition to the feedback from employers, we believe these changes will also make the claim filing process easier to understand for claimants and more efficient for the employment department to administer. The fourth modification states that claimants who search only for remote work are eligible for weekly benefits if remote work opportunities typically exist for their occupation. With the proliferation of remote work, seeking only remote work opportunities is a common practice for many occupations. So applying for these positions doesn't reduce the likelihood that the claimant will return to work quickly. Lastly, with the passage of Senate Bill 916, we need to establish eligibility requirements for claimants who are out of work due to a labor strike. Senate Bill 916 was passed by the Oregon legislature in the 2025 session and goes into effect on January 1st, 2026. Specific reference to striking workers has been added to this draft rule in Section 5 to clarify what requirements they must meet each week to be eligible for benefits. Subsection D establishes that striking workers will have the same requirements as claimants who are employer attached or are members of closed unions in good standing. This means that striking workers must stay in contact with their employer and return to work when the strike is over to be eligible for weekly benefits. Otherwise, striking workers will be subject to the requirements for being able to work and available for work as established in other sections of the rule. The conditions that exist around striking workers and their employers are consistent with those for employer and closed union attached claimants, so applying the same eligibility requirements makes sense. It will also allow us to leverage our existing structures and tools when striking workers file weekly claims. So before we move on to the question and comment portion of today's listening session, I'd like to address some feedback from Thursday's listening session. Questions were raised about how the Rules Advisory Committee will be formed for the official process later this fall. Going through these listening sessions, we intended to have the Employment Department Advisory Council serve as the Rules Advisory Committee, which we have done in the past. However, the OED Advisory Council recently lost a member, and likely won't have a replacement in time for the council to serve as the Rules Advisory Committee for these rule changes. Because of this, the concerns raised on Thursday, especially the ones around having a public employer participate on the committee, we expect to stand up a Rules Advisory Committee specifically for this fall's official rules process, though council members will likely participate on that committee. We hope to address the concerns already raised, but there are procedures that must be followed to set up the Rules Advisory Committee, so we can't make any decisions during today's listening session. We will keep everyone informed about the process as we know more. So we've now reached the question and comments portion of the listening session. Before we start calling on people for verbal questions and comments, I'd like to check with Seth to see if there are any questions in the Q&A box that would be helpful to address now.
No questions as of now.
Thank you, Seth. Okay, let's open the floor for verbal questions and comments. Click the raise hand button and we will call on people individually, and unmute your microphone so that we can hear you. Please make sure to state your name and organization if you're representing one, and let us know if you have a question or if you have a comment. If you prefer to ask your question or comment in writing, if you've not already done so, please submit your questions through the Q&A channel. Public comments can also be submitted by emailing oed_rules@employ.oregon.gov. Please include the full rule number and submit your comments by September 4th, 2025.
All right, we're going to start with Douglas Holmes. Go ahead and unmute yourself and you should be good to go. There you
Hello.
go.
Yes, got it. Doug Holmes. I'm with UWC. We represent business nationally in unemployment insurance. One question I have is how you were going to handle, how is OED going to handle a situation where the employer, where there is a strike, where the employer offers striking workers suitable work during the strike? That would seem to be disqualifying if they refuse to return to work. How will you handle that?
Thank you for the question, Doug. And so I might call on my panelists to see if they had thoughts on that. So if the strike is still ongoing and it would violate like the contract negotiations or things like that, we would have to look more into the specific situation. Obviously, if there is work available and they need to return to work at the end of the strike, then they do need to return to work. And so I'm not sure if Lisa or anyone else has thoughts on the answer to that question, or if we would need to follow up with Doug after.
We are looking into that situation because we would have to make a determination on the suitability of the work. And I've got a team that is looking into that particular situation right now. I am not comfortable providing an answer live. We need to do a little bit more research before we provide that response.
But
Okay.
thank you for raising that, Doug. And we'll
Yes.
definitely have something ironed out to answer that question, obviously before January 1st, 2026, so that folks know what to expect before the law or the rules go into effect. Did you have another question?
I
Or
do.
comment?
I know on trying to adapt for strikes, using the job attached procedure. It makes some sense, but it also raises a question about the scope of that. I mean, if the scope of using that for hiring halls is something that's fairly common, but if you try to expand that to other situations where there are, it's not a hiring hall situation, but there are people that are in a union and they're on strike, then it sort of raises questions about how do you determine whether, first of all, whether they're job attached, and then secondly, whether they are, in fact, searching for work or available for work through their union. I mean, oftentimes they don't have an agreement unlike the hiring hall situation.
Thank you. So in Oregon, we already have a provision for temporarily unemployed, and that's what we're sort of adapting to that employer attached, because claimants can frequently be confused about what that term means. And so for the closed union situation you were talking about, where they receive work through a union hiring hall, that works. That would continue to the work the way that it does currently. For the temporarily unemployed or employer attached, we already look at uh, when they're expected to return to work. And usually what we would look at is well, the claimant would let us know, and then the employer would let us know. And if they're in agreement, then they wouldn't need to come back to work until they were expected to return. If there isn't agreement, then they would follow regular work seeking requirements. So in the case of a strike, we would need to adapt that slightly. But if we have, we would have notification of the strike, we would know which workers are out on strike. If the strike were to end, then we get notification, we would change that. In the employer attached scenario, usually one of the parties would let us know that, oh, this person either refused work or the date changed and they needed to come back to work. And then, so then or they would say they're no longer employer attached. Unfortunately, we're not able to bring them back. So they need to, so then we would then inform them they need to follow the regular work seeking requirements. Does that make
Just
sense?
one more related, just to be sure I got you
Sure.
understood. So if the employer, the individual may self-attest, they think they're job attached, but if the employer says, no, they're not job attached, then you would apply the regular work search requirements?
Then we would do an investigation to see, figure out, where the miscommunication was, because there's a disagreement in what the claimant understands and what the employer understands, and then we would provide guidance. I mean, typically in that case, it all just depends, but usually if an employer is giving us a date to say that, or they're saying that a claimant is not attached, then we would let the claimant know that the employer told us that, and that this is the expectations for you to continue receiving benefits.
Okay. I mean, I have one other question, but I can wait if there are other people that have questions.
Okay, Doug, we can come back to you. Just once you go ahead and unmute, put your hand back up and we'll get back to you.
Okay.
Thank you. I'm going to go ahead and go to Lauren. Go ahead and unmute Lauren, and then after Lauren, we'll go to the question in the chat.
I just wanted to provide a very quick comment on the proposed update to 471-030-036. Just appreciate OED's work to clarify and streamline what our members do have to do to qualify for UI benefits potentially here. The proposed changes for hiring hall workers that are being dispatched appears just to be clarifying on language and condensing what already exists. I think we do have a question for union members that are not dispatched, but that does not impact our union. Thank you for your time on this.
Thank you, Lauren.
All right, we have a question in the chat, Lindsay, representative of COPACT, Coalition of Oregon Professional Associations for Counseling and Therapy. Question on 471-070-1000, which if I'm reading this correctly, is a paid leave rule. But let me get through the whole question. Maybe there's an interaction there. So it says that it has a list of healthcare providers that can certify a paid leave Oregon severe medical condition form. But it does not seem to include LPCs or licensed and marriage family therapists, even though they do have all the same rules and follow a similar code of ethics.
Seth, if I can break in for a moment,
Sure.
I think we're intending to answer that question in writing.
Okay. Then let's go ahead and go to Stacy. Stacy Michelson, go ahead and unmute yourself.
Yeah, thanks. Stacy Michelson with the Oregon School Boards Association. And really the question is, some of this is specific to school districts and the language that was included in 916. But Lindsay and team, I'm curious if you all have any intention to include a definition of back pay or future wages in future versions of rules.
Thanks for the question, Stacy. We weren't planning to include that into the rules because we felt the information in the statute was pretty clear, but happy to discuss that if that's something that you were hoping to see.
Okay, yeah, we can take some of that offline in a more, I don't need to take everybody's time with K-12 specific issues. But I'll send an email follow-up to you and Sravi and the team.
Great. Thank you, Stacy.
Thanks.
Okay, Doug, go ahead and unmute. Sounds like Doug may have stepped away or is having trouble unmuting, so why don't we go ahead and we can circle back again if needed to Cynthia. Go ahead and unmute.
Hi, everyone. Cynthia Bronger Munoz from the Oregon Education Association. Just a question on looking for work if you're not employer attached. Obviously we're representing teachers and they have a contract. Is there a way we could kind of honor that? Because being in contact with your employer 2 to 3 times when there's an active strike as an educator, but you have a contract that you can't leave or you will no longer have a license. I don't know. I guess in our world doesn't quite make sense. So I'm just putting that out there.
Yeah, thank you for the comment, Cynthia, about that. Yeah, school employees have some different regulations, as you know. And so that might be something where we can provide, specific guidance for school employees. We have a page about school employee wages and such. But if you have anything that you would like to share that would be helpful for the folks in your district, or just to answer those questions, we would love to get that feedback either now if you have it, or you can also just email it to us later because we would love to incorporate that information.
For sure. I will email you that information because we have, of course, special rules, which
Yes.
we should because we deal with young children.
Okay. Yeah.
Thank
That's what we're hoping to get today, is to make sure that we're taking everything into account and to make sure that we're, the intent is to make things clear and easy to follow. But if that is not, what we're doing, or if there's something that's missing, we want to hear about that so that we can either modify the rule, or we can provide information via the website, or things like that, to make sure that people know what to expect and what's expected of them.
All right, let's go with Madison Walters. Go ahead and unmute.
Yeah, hi, Madison Walters here. I am a political liaison for UFCW 555. We're Oregon's largest private sector labor union, representing workers in grocery, retail, manufacturing, and healthcare across the state. I just wanted to take a moment to comment and just thank the OED for preparing these listening sessions to give us a chance to review the proposed rulemaking language in advance and make some comments. From our perspective with our members, we feel that the suggested language in regards to workers on strike makes sense. Workers on strike are choosing to strike in order to improve wages and working conditions with the explicit intent of returning to work once that strike has ended and once a contract has been settled. So we believe, that makes sense. And just in terms of, I know that there had been some comments at the last listening session about providing job-seeking activities for striking workers. Just given the intent that a striking worker, intends to return to work with their current employer, in our minds, providing proof of job-seeking activities is antithetical to the purpose of the strike, and will result in some kind of redundant busy work for both the worker and for the employment department. So, with that in mind, we're very supportive of the language as proposed, and look forward to following the RAC process closely this fall. So, thank you.
Thank you for the comment, Madison.
It looks like we don't have any raised hands, but Stacy, I will double check on the school reference page. I do believe it is live, and I'll track that down, and we can get that link in the chat. Susan, go ahead and unmute.
Thank you. My name is Susan Allen. I'm with Oregon AFSCME. I just want to sort of lift up, Madison did a great job framing for her workers because AFSCME represents around 40,000 members statewide, both in the private and public sector. And the intention of our workers who are very vested in their jobs and invested in their jobs, the intention is for them to get back to work. So we actually really appreciate the opportunity to take a first look at and give you some informal comments on these draft rules. They do seem right thinking to us, and we look forward to shepherding the process that goes forward. Thank you.
Thank you for the comment, Susan.
Looks like we have another question in the chat. Are there any time limits associated with someone who is coded as employer attached temporarily unemployed?
Thank you for the question. There isn't a time limit. So currently we have that 4-week limit. We're removing that. And so based on the feedback that we heard, employers wanted more flexibility in order to be able to say, this person that I hired and I trained and I invested in, I want them to come back to work for me. I don't want them to look for other work with another employer. So I'll let you know. So as long as the claimant and employer agree that they're coming back to work, there wouldn't be a specific time limit. That could vary case by case if an employer says they're coming back in 2 weeks or they're coming back in 4 weeks and the claimant agrees. But right now there's nothing prescribed for it that would apply to everybody.
Flannery, go ahead and unmute.
Hi there. Can you hear me?
Yes.
Yes.
Flannery O'Rourke National Employment Law Project, which is a nonprofit advocacy organization. So I just wanted to briefly comment on this question of whether workers that are on strike or otherwise unemployed due to a labor dispute can accept suitable work. So first, I would point out as kind of our starting place that right now, prior to this change that broadly removes the labor dispute disqualification, there already are certain workers who are on strike or otherwise unemployed due to a labor dispute who are eligible for unemployment in unemployment insurance in Oregon. So if you look at Oregon Statute 657.176, the state already extends UI to workers when the employer breaches the contract. And then if you look at 657.200, there's already a lockout exception. So just to say this is a change, but it's we're already, the state is already extending UI to some workers during labor disputes. And so then considering suitability, Oregon defines suitability factors in a current statute, that 657.190, and it says the Director of Employment Department shall consider, among other factors, the degree of risk involved to the health, safety, and morals of the individual. And there's also other federal and Oregon law that addresses that a job that is subject to a labor dispute is not suitable. So Federal Unemployment Tax Act requires that states exclude jobs made available to a labor dispute from the definition of suitable work. That's 26 USC section 3304A5. And of course, Oregon adopted this language in 657.195(1A). Certainly, there's an argument that accepting struck work violates a worker's morals under that prior Oregon suitability statute. And I also think if we just kind of take a step back, the Oregon legislature and governor have been support for removing the labor dispute disqualification and extending UI to workers who are unemployed due to a labor dispute. And inherent in that support is that these workers can meet existing state and federal requirements for UI, even while on strike or otherwise unemployed due to a labor dispute. And as I said, there are already some workers right now, even prior to this change, that are doing so where they are on strike because their employer breached their contract or they are locked out and they are currently eligible or not disqualified from UI. And then the final thing that I would just lift up is what a prior commenter said, and I think I said on the last call, which is that you are no more job attached. You could not be any more job attached than when you remain at your job, even though your employer is engaging in unlawful actions or you are so committed to changing and improving the working conditions of your employment that you would go on strike rather than leave employment. Thank you.
Thank you for that comment, Flannery. So it look good.
I was going to say, we want to do the, I think we have at least one open question about back pay. Going back to the beginning of a strike, does that mean recipients of benefits will be required to return unemployment benefits to the state?
And thank you for that question. So it is going to depend. It's going to depend on what that back pay is compensating for and when it's received. We look at that on a case-by-case basis. So it could be that it would need to be returned, but it might not be. We learned, especially during the Senate Bill 916 hearings, that different employers, especially school districts, might define back pay slightly differently than other entities. And so we would need to know what is that, when are they receiving, what is it covering, and we would look at all of that, and then there could be an overpayment or there might not be.
And there's also a question from Daniel Feng. Can I apply for out-of-state job as a direct contacting the employer for the weekly claim?
If So there's a couple different pieces with that. If you are applying for remote work, so you're in an industry and you have the skills and the experience to accept that type of work, you have the tech in order to be able to do that, and that work is out of state, that is appropriate as a direct employer contact. Alternatively, if you're looking for a job and you're looking to relocate into another state, that might also be. If you have a question about specifics, we're happy to answer those. But usually when you've done your RESEA appointment and met with us, we provide you with those work seeking guides to let you know what type of work you should be looking for and if something is appropriate. But if you have a specific question about your own claim, you can either give us a call or submit it via the contact us form on unemployment.oregon.gov/contact. And then we can provide you with specific information to your claim type.
And let's go back to Douglas. Go ahead and unmute yourself.
And Doug, before you jump on, I just said claim type. That's not right. It's the specific situation around your claim. There aren't specific types of claims that have in this situation. So sorry, that was just, I misspoke. So I wanted to clarify. Go ahead, Doug.
Okay, sorry I got frozen out there by my own system. So
I'm sorry to interrupt you, Doug. This is the ASL interpreter. Truly apologize for interrupting this session, but can we have the other interpreter spotlighted so you can switch me out, please? Thank you kindly.
Thank you for interrupting and letting us know.
Thank you. Yeah, and when I read the 916, I thought and I didn't look at it closely enough, but I thought, how does this, if you've got an overlap, if there's a strike and an educational institution, you've got an overlap between the period of the labor dispute and the between terms denial period, how would you reconcile those two provisions?
Thanks for the question. So the rules around school employees are very detailed and can be very case by case specific. And so we would look at the situation around the strike. Are we dealing with a bargaining unit that is mostly teachers? Is it employees that are in what's called in the federal regulations as a non-professional, and what are the requirements for reasonable assurance and other specifics around school employee wages, and would provide guidance at that time about what nuances might impact. It's really difficult to say blanket, if this were to happen for this type of unit, when it comes to school employee wages, this is how we would interpret that. Generally, we'll, put together the guidance as we have for the striking workers, and then also we have a school employee webpage, and so we might provide some updates there. But we might need to look at, as a strike is happening or once a strike occurs, what specific guidance we need to provide to those workers, and we get that out there to make sure that they knew it was required of them.
On the interpreter front, it looks like the other interpreter has dropped off the call. I believe that is the issue right now. Maybe we can give our interpreter a minute of a break, and then we can take the next question.
No, that's fine. It's fine. I'm fine. It's totally fine. Thank you. I appreciate that.
Go ahead, Doug. Did you have another question?
One last question. So on the question of job attached, I mean, that's always, that can be a difficult thing to sort out. But did I already ask this question? I mean, how do you determine whether someone is job attached if they make an application and they self-attest that they believe they're job attached, but I did ask this question. The employer disagrees. So sorry.
Oh, no worries. I'd rather you ask it twice than miss the opportunity. Of course, if you think of things after, there is the OED _ rules at employ.oregon.gov to send in, comments or other thoughts, but no worries, Doug.
Well, I can think of another question if you want another one.
I mean, that's what the time is here for.
Well, on the question of availability, I mean, if there's no, I mean, it's always a difficult question. Are these individuals, I'm talking about people that are on strike, what if they say nothing? If there's nothing, there's no evidence, and there's no documentation or information, are you just going to assume that they are available? Or are you going to, ask for some information from them that demonstrates that they are available to return to work, or that they can meet the availability requirements?
And you're talking specifically to the striking workers?
Well, yes, I am. I mean, I'm interested generally, but it comes up it can be most acute when you've got large numbers of people that are all applying, and the question might be, well, if their union sends in something that says all these people are available, is that sufficient, or do you need something from each individual applicant, claimant, and also something from the employer that speaks to each one of those claims as part of the adjudication of whether they're available or not?
And so each week that a claimant is seeking benefits, they do need to submit a weekly claim certification and say that they are able to work, available for work, actively seeking work. It's about 9 questions that we ask them each week. And so that would still be a requirement for striking workers. So they would need to say that they are available, and we would define, what that is to make sure that they're providing accurate information. And so we would, rely on that, but also if we got, conflicting information about someone's availability, then we would do an investigation. It's also possible that folks might have weeks of unavailability. That's not uncommon for any unemployed claimant to have, say, a pre-planned vacation. They weren't planning on separating from their employer, but the tickets are already bought and the kids are excited, so you're going to go on that vacation. You wouldn't be available for work, to return to work that week, so you wouldn't be eligible for benefits. But then when you return back to the labor market and doing everything that you're expected to do, then you would be available the subsequent week. So we just need to know that, if they claimed, that would be denied, or if sometimes they just don't claim that week and then they just reopen the next week. So
Thank you.
It looks like we have a question in the chat. The new rule allows employees to seek only remote work if remote work is typically available for their occupation. Is that correct? How does the employment department determine if it is typically available, especially if their previous employer didn't allow it?
So we're going to look at, again, the skills and experience of the individual, their locality, what type of work they're seeking, what type of work they're capable of accepting. And then generally, if there are a lot of remote work opportunities out there, they can limit themselves to just remote work. If that's not the case, or they're in an area of the state that, say, doesn't support, they don't have the fiber in order to be able to, have an online job, then we would we would change their work seeking requirements and say, oh, no, you're applying for work as a barista. That is in office work. So that would not be appropriate for remote work. But this allows us the flexibility to look at someone's, what type of work they're looking for and what they're seeking, and then be able to say, yeah, for this one, that's okay for those to be remote only, direct employer contacts, and others might not be. There's also, we take into consideration how long someone's been unemployed. So if a worker was taking that tactic, and after an amount of time that we would reasonably assume they would return to work based on the type of industry that they typically work in and what we're seeing in the job market, we might say, oh, you need to add in some in-person contacts to help you get back to work. Because the whole goal is to make sure that people are getting back to work quickly, and that they are, again, returning to the job market. But we just didn't want to put, as the state, additional limits in the type of work that they're looking for, if it's not something that's going to, one would reasonably expect would limit their job search. So if, like I said, if it is an industry or a type of work or locality or other things like that, where that remote work is limiting, and we're like, we would tell them they need to look for other types of work. And in other situations, it might totally be appropriate. And that's going to change over time. So I think in the last listening session, somebody brought up, well, a lot of employers are expecting people to come into the office. If we start seeing that trend continue, or if that is particularly true of one type of industry or not, that that could change for that particular claimant for a time. So it's just to add that flexibility in there.
Looks like no other questions at the moment, unless Deb wants to clarify. It seems to me that one is a comment.
Did you want me to ask another question?
If you've got one.
Oh,
Not putting you on the spot, Doug. If you don't have any questions, it's okay.
No, well, I mean, I had another one. I'm just wondering how the rules and how you're going to administer the new statute, how that fits with SIDES. I know SIDES has a labor dispute code, but I'm not sure how I don't know that there would be any difference between what is done with SIDES, but that would be a systems question about how does this fit? How are you going to fit this in with what's already there in SIDES?
Yeah, off the top of my head, I don't have that planned out, but we'll definitely make sure to have guidance for employers that use SIDES to ensure that they, that anyone that uses SIDES, that they know how to, provide the answers within that. Both New York and New Jersey have had UI for striking workers for some years, and I believe they also use sides. So I'm sure there's a way to do it. I just don't know off the top of my head how that would be, but I do know we'll make sure to provide guidance ahead of anything going into effect.
Okay, thank you.
You're welcome. And we got another question in, or it was a continuation of the prior question that's in chat. And so talking about when an employer leaves work, or employer, excuse me, when someone, a claimant, leaves work because they don't want to come back in the office. And so just to clarify, what we're changing is the type of work that they're looking for when they're on unemployment. If someone refuses an offer of work, acceptable work, or if they are to, quit a job because they need to come back into the office, that's actually not impacted by this. That's a different rule that we look at and see if they have good cause for the job refusal or the quit. We kind of look at what's the situation around why they left work. And that part's not changing. But thank you for adding the comment in there.
Let's go ahead and go to Daniel. Go ahead, unmute yourself.
Can you hear?
Yeah.
Yes.
Yeah. My question is, if there's an employer, they don't have a job, can I apply to send my resume to them as a direct contacting to employer as one of the two direct contacting for the weekly claim?
Thank you for the question. So when you're applying for a direct employee, where you're doing one of those direct employer contacts and you're applying for work, you need to apply for jobs that are available and in the format with which the employer is asking for applications to be submitted. So I understand your question to be, if they don't have a job and you're just sending a resume, would that count? Typically that wouldn't count because they don't have a job available.
So if my job is very narrow, there's no many employer for my professional area. So what should I do?
I would encourage you to reach out to the WorkSource Oregon office that you should be connected with. They can provide you with more information about job postings that they have, what sort of work seeking, what other jobs might be available, what trainings might be available for you to participate in or to expand your job search if that's what's needed. But usually they have lots of great connections with employers and jobs that hopefully you can get connected to and get back to work.
Yeah, but the truth is, my type of career is really difficult. It's instrument, a music instrument. Is from a young age as a professional now, so it's really difficult to find an employer as music industry in the Oregon.
Okay. Well, thank you for providing that additional information. And this is a public webinar, so we don't usually talk about claim-specific information. So
Gotcha.
I'll take that as feedback on the rules. But I would encourage you to reach out to the WorkSource Oregon office, and they can kind of talk to you more specifically about your particular situation, the type of work you're looking for, and hopefully get you some great advice on how to find a job.
Thank you very much.
You're welcome. Thanks for participating today.
We've got no more questions in the chat, no hands raised. Maybe make a last call for questions, give folks another couple minutes, and if we don't have anything more, we'll call this session.
Looks like we have a hand up.
Sorry about that. Go ahead, James.
Hi there. Thought I'd end this off with what I think I know the answer to. James O'Loughlin with Laborers 483. In terms of the beginning of the unemployment insurance availability for striking workers, how is it handled if there is a labor dispute in the end of 2025 that crosses over into January 1st?
Thank you for that question. So the law goes into effect on January 1st. In the situation you're talking about, where it were to continue, it, let me think about that for just a minute. So, likely, I'm assuming if they're on strike, they haven't filed an initial claim, and so they would need to file that initial claim to start that claim year, and we would determine, did they work enough hours and earnings in their base year and all those other eligibility requirements. For striking workers, the first week of the strike, so the first week, in this case, even though it's not the exact first week of the strike, it would be continuing. Oh, I'm so sorry. I've got a correction from one of my SMEs. So the Senate bill applies to strikes that begin after the effective date. So in this case, if that were to start in December and then continue through January, they wouldn't be eligible for benefits because the strike needs to start after January 1st of 2026.
Okay, that's very definitive. Thank
Yeah,
you.
that's a much cleaner answer than I was going to provide with all sorts of different scenarios. So thank you to my SMEs for that prompt.
I think we're coming up on 5 o'clock. We can give another last call. I think while we're giving folks another minute to potentially ask another question, we can express our appreciation for everybody participating on Thursday and today. We really appreciate everybody's feedback and look forward to the official rules process this fall.
And I'll go ahead while we're waiting and just clarify, because I started to talk about some of the Senate Bill 916 requirements for striking workers. So I'll just go ahead and finish that thought out, even though in the scenario that was presented, the workers wouldn't be eligible because the strike started before the effective date of the law. But if it were to start after, say, second or third week of January, claimants do file their initial claim for benefits, and then we do all of our regular checks to make sure that they have eligibility. If they're eligible for benefits, that first week is going to be sort of a claim suspension week. So you're not eligible for benefits that first week. The second week is going to be the regular waiting week. So all claimants have to serve a waiting week in Oregon for each claim that they serve. And then the third week would be the week with which they can actually start receiving benefits. You still need to meet all other eligibility requirements. So just because you are a worker on strike doesn't automatically make you eligible for benefits. So if you had a disqualifying event or other things that prevent you from being eligible for benefits, those still apply. The law simply removes that before striking workers, you wouldn't be eligible. So this just removes that piece of it. So hopefully that provides a little bit more clarification, just to add on to kind of what I started, but then didn't finish up.
I think we'll just give it another minute or so and then wrap things up. Thanks again, everybody.
All righty. Looks like we've got all the questions. Thank you for joining us today and providing your feedback. This recording will be posted at our listening session webpage, and the link to that is in the chat. You can also submit comments through September 4th by emailing OED_rules@employ.oregon.gov. Make sure to include the full rule number in your comment. Thanks again for your participation. We very much appreciate it. Have a great afternoon.